The first case is 01609 in the matter of Jennifer Lane Bicknell. Mr. Knox.
This case concerns the issue of two women who are raising children together and wanted to adopt the same surname so that the entire family could have the same last name. They sought their name change to the name Ryland, which was actually chosen because it was a combination of letters from each of their last names. Looking to the statute
We just knew that was the closest thing we could come up with to be a family. Isn't that pretty much it?
I didn't want Bicknell, and she didn't want Pretty, so...
Yeah, we didn't want to take each other's last names.
We couldn't think of a name out of the blue, so finally we just sat down and picked a couple of letters we each liked out of our own name, played with it, and came out with Ryland. And it fits.
And when they made their applications, the purpose they put on the application forms was that it was for the best interest of their children. They were raising kids together, and they want everyone to have the same family name. They sought their name change to the name Ryland.
And we didn't think it'd be a big deal.
Right.
We didn't even have an attorney at the time. We thought we would go in. We even held off on buying new checks from our bank so we could have the right last name on them. And we thought we would go in, get our new last name, go to the driver's bureau, to the license bureau, change our license, and go order checks and be done with it. But it didn't happen that way. We started the whole name change process in late 1999, and then we went to court in February of 2000, and then went to the appeals court in November of 2000, and then now we're up here. So it's been a couple years that we've been doing this.
Last names. Looking to the statute only requires that there be reasonable and proper cause for the name change. In this case, the Butler County Probate Court.
The case originated, I think it was November of '99, when they called, Jennifer, I think, called and said that they wanted an appointment because they'd been turned down for a name change. I have done name changes for women and for men couples with kids and without kids. Some couples have changed their names because they've been together for 10 or 15 years and they want to share the same last name to let their families and others know, and each other know this is for good. I've done, at that time, I'd probably done close to a dozen for exactly the same reason in Hamilton County for years. And what the law has always been interpreted to say is if you're not changing your name for fraudulent reasons, to defraud creditors or avoid criminal charges or something, that you get your name changed. So I said, sure. And she says Butler County, and I usually don't practice in Butler County, but it's not that far, and I couldn't think of anyone to refer them to, so I just took it. I told them, I said, I have to tell you as your lawyer, if you moved to another county, you would get this like that. But I said, I personally hope that you stand and fight because things don't change.
My name's Chuck Hickey, and I'm a pastoral intern at the Church of the Covenant in Cincinnati, Ohio. And I'm here to observe the arguments in the Supreme Court of the state of Ohio regarding the name change for two cohabitating ladies. Our interest is primarily in promoting traditional family values in regard to biblical values in the marriage family, the marriage institution. We believe it's an institution that was begun by God with the creation of Adam and Eve. And because of that, we think that this kind of situation where two ladies are desiring to have the same name really buffets against the notion of a biblical marriage.
Good morning. May it please the Court, my name is David Langdon. I represent the Amicus American Family Association of Ohio. We submit that there are two issues before this Court today, both of which will need to be decided. And the first issue would be, what does the reasonable and proper cause language in the statute mean? How is that language to be interpreted, specifically in the context of a name? The second issue we submit that then must be decided once it is determined what the standard is did the probate court properly apply that standard to reach its ultimate decision?
Probate court. You go into probate court, you fill out an application for name change, you put your birth date, that you lived in the county for at least a year, and your reason for wanting the name change. They put that they were going to be having children and they wanted to have the same name because they were going to be raising kids together. It gets published in a newspaper of general circulation for 30 days, and I think it's 3 or 4 weeks. And then you have a hearing where you go into the hearing and the judge asks you questions traditionally about fraud to see if you're really changing your name for reasons that comply with the statute. If he decides or she decides that you are, that your reasons comply with the statute, then they grant the name change.
We know that the counsel for the appellants here suggests that the term proper only has a function as to whether or not the name is fraudulent. How would you put boundaries on the term proper in the statute?
Limiting the interpretation of proper to non-fraudulent and non-fraudulent only will in essence take away any discretion that a probate court judge has in these name changes cases. We have a name change statute, and an inevitable byproduct of this statute, quoting a case from New York, is that the aura of propriety and official sanction is placed upon the name if the state grants it. In this particular instance, from the beginning of this state's existence, really, back in 1803 when it was admitted into the Union, Ohio has discriminated and said we want to favor traditional marriage between one man and one woman and nothing else.
It's turned into this major issue that it shouldn't be. You know, people change their name every day, and they've tried to turn it into this gay marriage rights. I'm not asking for anything. My name doesn't give me any special rights. You know, I'm just a person that wants to change my name.
We know that we do not have same-sex marriages, and I cannot comprehend what the Court of Appeals majority opinion was talking about, that giving this couple, these two women, and the family the same name would in any way, in anyone's mind, indicate that the courts are sanctioning same-sex marriage.
Well, I think historically and traditionally, names have been, a common name has been a distinctive of family. And when, in this case, two cohabitating ladies are trying to share the same name, which would be a distinctive of a traditional family. And in that sense, we would disagree that that's something they ought to be able to do, because it does go against public policy and the legislative intent of the Ohio House in bringing about a traditional family structure as being the prominent institution in the state.
The Ohio General Assembly and Ohio common law specifically hold that same-sex relationships are not valid, and frankly non-marital relationships, whether it be homosexual or heterosexual, have no legal validity. And so we would ask the court not to give any validity to that type of relationship by granting a name change. That there is no distinction between whether or not we're dealing with a homosexual couple or a heterosexual couple. The distinction is whether or not they're married. And the argument is that Ohio does indeed have a strong public policy. Ohio does indeed have a strong public policy that favors traditional, solemnized marriage and withholds any type of official sanction from non-marital cohabitation. I've cited numerous statutes as well as cases decided by this court, cases that have not been overturned, the Stiles case, the Grant v. Brown case, which specifically state that Ohio has a public policy that disfavors things such as homosexuality and cohabitation, non-marital cohabitation, fornication, adultery.
We do favor marriage. We give them perks, automatic inheritance rights, all sorts of perks. But it's never been read into a neutral law in Ohio that people who cohabitate can't use this. If the statute says that, fine, but this is a neutral statute. It doesn't say you can only use this if you're married.
Give me another example. When you apply in probate court to have a will admitted to probate and accepted by the court, when the court accepts the will, they're not saying, we think all the terms of this will are great. We think that Johnny should have been disinherited because he was hateful. They're just saying it meets the statutory prerequisites for being a valid will. They're not endorsing everything that's in it. In courts here, when they do a name change, they don't endorse the subjective reasoning behind it. They endorse, you met the statute, and for the goal you have, it seems reasonable, and it's not fraudulent.